Hello everyone, welcome back to the channel EduTap. I am Arshdeep Kaur and I am back with another act, that is the Depositories Act 1996. We have already done 2 lectures on the SEBI Act and now this is our first lecture on the Depositories Act. As you already know that security laws, they have been given 40% weightage. And I have been stressing on this point from the very beginning that the security laws, they form a very crucial part of your examination, so you have to prepare them very carefully, right? Because 40% weightage, it is huge, so please do not leave these questions, do not leave these acts, all these regulations, they are very important for your examination. Before I start, I would like to tell you that EduTap has come up with 2 courses. The first one is the test series and the other one is the live crash course for your SEBI preparation for the phase 2. If I talk about the test series, the features of the test series includes, first is chapter wise test. So you get chapter wise test. Your syllabus, the acts, they have been divided into different chapters, right? Like for example, if we talk about IPC, chapter 1, chapter 2, chapter 3, same for security laws and same for company laws. So you get test for each of these separate chapters that have been provided in different acts, right? So the first one was chapter wise test. The second one is the full length test and it also includes your descriptive part. SEBI has first time introduced the descriptive part, so you have to be very careful while you prepare for this part. Don't take it lightly. 30 marks have been given to this descriptive part. So in this full length test, you will also get questions related to the descriptive part and you also get evaluation. That means our experts are going to evaluate your tests and are going to give you feedback and guide you throughout the process and will let you know about any scope of improvement wherever needed, right? So this is going to be very helpful to you and you also get one-on-one mentor support. If I talk about the live crash course, it includes the live classes. So you get live classes on each and every important and relevant topic of your syllabus. Every important topic is going to be covered in these live classes. Plus you get short notes. For the descriptive preparation, they are going to be very helpful, so please make sure that you prepare for them very carefully this time. And all the features of the test series, they are also included in this, that is the live crash course. And plus you also get one-on-one mentor support. So please don't take this exam lightly. It is going to be a difficult one this time and now the real competition has started, so please be very careful and be very present while you prepare for your examination. We are running a limited time period offer on both these courses, so please make sure that you avail it. So those of you who want to join can refer to the link in the description below. Now let's start with our lecture. Question number 1. Consider the following statements relating to the Depositories Act. First, the Act came into existence in 1996. It has 31 sections. An act to provide for regulation of stock exchanges and for matters connected therewith or incidental thereto. So choose the correct option using the code given below. So the answer to this question is option C, that is the first and the second statement, they are correct, but the third one, that is an act to provide for the regulation of stock exchanges, this is wrong. But the correct answer is an act to provide for regulation of the depositories in securities and for the matters connected therewith or incidental thereto. So this has been mentioned in the preamble of this act, right? So let's read this again. Depositories Act 1996, it came into force in 1996, right? It has how many sections? It has 31 sections and it is an act to provide for regulations of depositories and securities and for matters connected therewith or incidental thereto. Question number 2. Once a security is converted into a digital form, it is registered with a depository. Depository becomes a registered owner of it, and by what name the actual owner is called? So the answer to this question is the beneficial owner, that is option C, right? So beneficial owner means a person whose name is recorded as such with a depository. And depository, what is a depository? Depository means a company formed and registered under the Companies Act 1956 and which has been granted a certificate of registration under subsection 1A of section 12 of the Securities and Exchange Board of India 1992. So let's understand what is this depository, who is a depository participant and what is this concept of depository system, right? So a depository, it is an organization that holds securities. Which securities? For example, your shares, your debentures, bonds, government securities, mutual funds. So the organization that holds these securities on the request of the investors in electronic form through depository participant is known as a depository. If you want to understand what is a depository, you can compare it with a bank. Like for example, you deposit your money in the bank and the bank keeps your money safe, right? In the same way, you deposit your securities. They can be shares, debentures and any other security with the depository, right? So it is just an organization that is keeping your shares, right, in electronic form. This is known as what? This is known as depository. And who is a depository participant? You can compare it with a bank agent. Like a bank agent, he helps you to open a bank account in a bank, and he also provides you with other bank services. In a similar fashion, depository participants also helps you open a demat account. We will be dealing with what is a demat account also. So he helps you to open a demat account and also provides with different services, depository services. So he provides you different services and he acts as an agent of the depository, right? Now I mentioned a term, a demat account. So what is demat account? Demat account is a similar way that like you open a bank account. In similar way, you open a demat account in depository. Demat account is an account where you keep your securities in electronic form, right? So this is what this is, demat account. So I hope now you are clear with depository, depository participant and a demat account. And the last one, who is a beneficial owner? He is the actual owner, right? So who has deposited his securities with the depository, he is known as what? He is known as the beneficial owner. He is the true owner of those securities. Now let's read it. It will be more clear to you. Beneficial owner means a person whose name is recorded as such with the depository. Depository means a company formed and registered under the Companies Act 1956. So it is registered under the Companies Act 1956, been granted a certificate of registration. A depository cannot act as a depository without this certificate, of registration, right? So he has been granted this certificate of registration under subsection 1A of section 12 of the Securities and Exchange Board of India 1992. I hope now this concept of depository, depository participant, beneficial owner, depository system, this is clear to you, right? Alright, moving on, question number 3. Which of the following are true statements related to the participants of stock market? Functions of clearing houses can be transferred to clearing corporations. Investor can trade in secondary market through broker using demat account. Stock exchange facilitates trading of stock amongst shareholders and between company and shareholders. NSCCL is the clearing house of NSE, or all of the above. So the answer to this is E, that is all of the above. All of these statements, they are correct, right? Moving on, question number 4. For depository to function smoothly, it takes help of various depository participants by making an agreement as per the Act. Which of the following is correct in this context? The agreement between them shall be as per the bylaws of the depository. The depository shall enter into an agreement with one or more participants as its agents. The depository shall enter into an agreement with one or more participants as its subsidiary. So the answer to this question is D, that is first and the second, these statements are correct. The agreement between them shall be as per the bylaws of the depository, and the depository shall enter into an agreement with one or more participants as its agents. So I have told you that they act as their agents. Agreement between depository and participants, section 4. A depository shall enter into an agreement with one or more participants as its agent. Every agreement under subsection 1 shall be in such form as may be prescribed by the bylaws. Question number 5. Which of the below statements relating to the dematerialization process is valid? Issuer, on receipt of certificate of security, has to cancel the certificate of security and substitute in its record the name of the depository as a registered owner in respect of the security and inform the depository accordingly. physical certificate holder should first surrender the certificate of security to the issuer for which he seeks to avail the services of a depository. A depository shall enter the name of the person in its record as the beneficial owner, A or C only, or all of the above. So the answer is E, that is all of the above. So before reading the explanation, you should know that what is dematerialization. Dematerialization is nothing but it is just the process whereby the physical shares, they are converted into electronic form, right? So when your shares, not just shares, when your securities actually, so when the securities are converted from a physical form into the electronic form, it is known as what? It is known as dematerialization, and where they are kept, it is known as a demat account. So dematerialization is nothing but the process by which physical certificates of an investor are converted to an equivalent number of securities in electronic form and credited into the beneficial owner's account with his depository participants. So I hope now you are clear with what is dematerialization as well. So now back to the question. The answer was E, that is all of these statements, they are correct. Let's read these statements again. Issuer, on receipt of the certificate of security, he has to cancel the certificate of security and substitute it in records the name of the depository as registered owner in respect of the security and inform the depository accordingly. The physical certificate holder should first surrender the certificate. So he has to surrender the certificate first of the security to the issuer from which he seeks to avail the services of the depository. And the last one, a depository shall enter the name of the person in its record as a beneficial owner. Question number 6. What does it mean by surrender of certificate of security by the owner? Surrendering those shares for whom there is no conversion into electronic format possible, surrendering those shares in order to obtain the shares in the electronic format in the demat account, selling those shares at the face value by surrendering the certificate of security, A and C only, or all of the above. The answer is B, that is what is surrendering. Surrendering means surrendering those certificates in order to obtain the shares in the electronic format in the demat account. So once you want to convert your securities into electronic form, you have to do what? You have to surrender your certificate. You have to surrender the certificate of your physical security, right? So you have to do what? Surrender those shares in order to obtain the shares in electronic format in the demat account. And how do you surrender this? Let's read this. Any person who has entered into an agreement under section 5 shall surrender the certificate of security for which he seeks to avail the services of a depository to the issuer in such manner as may be prescribed by the regulations. The issuer, on the receipt of the certificate of the security under subsection 1, shall cancel the certificate of security. He is going to cancel it, and then he is going to substitute in its record the name of the depository as the registered owner in respect of the security and inform the depository accordingly. So whose name is being registered? It is the depository's name, right? Because he is deemed as the owner, right? So whose name they are registering? It is the depository's name, right? And the third one is, a depository shall on receipt of the information under subsection 2 enter the name of the person referred to in subsection 1 in its record as the beneficial owner. So by reading this, now it also becomes clear that who is a registered owner and who is a beneficial owner, right? Alright, question number 7. Section 10 of Depository Act 1996 details the rights of depositories and beneficial owners. In this context, identify the incorrect statement. A depository shall be deemed to be the registered owner for the purpose of effecting transfer of ownership of security on behalf of the beneficial owner. The depository as a registered owner shall not have any voting rights or any other rights in respect of securities held by it. The beneficial owner shall be entitled to all the rights and benefits in respect of his securities held by a depository. And the last one, the beneficial owner shall be subjected to all the liabilities in respect of his securities held by a depository. So the answer to this question is E, that is all of these statements, they are incorrect. Let's read the correct statements, right? So rights of depositories and beneficial owners. Section number 10. notwithstanding anything contained in any other law for the time being in force. So that means this has a overriding effect, right? A depository shall be deemed to be the registered owner. This we have covered. A depository is deemed to be the registered owner for the purpose of effecting transfer of ownership. For what purpose? For transfer of the ownership of security on behalf of who? The behalf of beneficial owner. The original owner is the beneficial owner only. Save as otherwise provided in subsection 1, the depository as registered owner shall not have any voting rights. So he is not given any voting rights or any other rights in respect of securities held by it. The beneficial owner shall be entitled to all the rights and benefits and be subjected to all the liabilities in respect of securities held by a depository. So all the rights, all the liabilities of the securities, they rest with who? They are with the beneficial owner only. So the beneficial owner shall be entitled to all the rights and benefits, and he also will be subjected to the liabilities in respect of his securities held by a depository. Alright, question number 8. As per section 11 of the Depositories Act 1996, register of beneficial owners shall be maintained by which of the following? So the answer to this question is D, that is the depository. So the depository, he has to maintain a register with all the names of the beneficial owners. Register. Every depository shall maintain a register and an index of beneficial owner in the manner provided in section 150, 151 and 152 of the Companies Act 1956. And the manner in which that register is going to be maintained, it has been given in the Companies Act 1956 under section 150, 151 and 152. Question number 9. What is the full form of CDSL? So the answer is A, that is Central Depository Services Limited. CDSL is the depository of BSE, whereas NSDL is the depository of NSE, right? So let's read it. CDSL is the depository of BSE and NSDL, it is the depository of NSE, and their full forms. CDSL, it stands for the Central Depository Services Limited, and NSDL stands for the National Securities Depository Limited. Question number 10. During an IPO, a company issues securities to investors. In which form the securities are issued? So the answer to this question is D, that is Demat. An investor, he can have his securities in Demat form. So the answer is option D. Question number 10. Under which section of the Depository Act 1996, SEBI board has power to call for information for OR, make an inquiry against the depository participant or the beneficial owner? So the answer to this question is D, that is section number 18, right? This section number 18, this is important from your examination point of view. The board, on being satisfied that it is necessary in the public interest or in the interest of the investors, so to do, may by order in writing. So the board is going to make an order in writing if it thinks that it is in the interest of the investors and in the interest of the public, right? What is going to be the order? First, call upon any issuer, depository, participant or beneficial owner to furnish in writing such information relating to the securities held in a depository as it may require. So they can call them and can ask them to facilitate any information, and that information is going to be given in writing, and it is going to be related to what? The securities that are held in the depository, right? Authorize any person, or the second one, they can make an order to authorize any person to make an inquiry or inspection in relation to the affairs of the issuer. So they can ask any person to make an inquiry or inspection with relation to the matters concerning their affairs. Affairs of who? The issuer, beneficial owner, depository or participant, who shall submit a report on such inquiry, and that person, he is going to submit the report on such inquiry or inspection to it with such period as may be specified in that order. Every director, manager, partner, secretary, officer or employee of the depository or issuer or the participant or the beneficial owner. So all these people, they shall on demand. So whenever they So whenever asked, they have to produce before the person making the inquiry or inspection all the information or such records and other documents in his custody having a bearing on the subject matter of such inquiry or inspection. So whenever asked for, they have to provide all the documents, all the records that has been demanded by them. So I hope this section is clear to you. Moving on, question number 11. If any depository or participant or any issuer fails to redress investors' grievances within the time specified by the board, what penalty they will be liable to pay? Is it at least 10 lakhs or 10 lakhs per day during which such failure continues, maximum of 10 crore, A and B, or none? So the answer to this question is actually E, that this is incorrect. It is at least 1 lakh and then 1 lakh for each day when the failure continues and maximum of 1 crore rupees. Let's read this also. It is under section 19C. If any depository or participant or any issuer or its agent or any person, so all of these persons, they will be liable. The depository, the participant, the issuer or its agent or any person who is registered as an intermediary. Under the provisions of section 12 of the Securities and Exchange Board of India 1992, after having been called upon by the board in writing to redress the grievances of the investor fails to redress such grievances. So they were asked, they were given an order by the board in writing to redress the grievances of the investors, but they failed to do so, and in that case, what is going to be the liability? So fail to redress such grievances within a time specified by the board, such depository, the participant or issuer or its agents or intermediary shall be liable to a penalty which shall not be less than 1 lakh rupees but which may extend to 1 lakh rupees for each day during which such failure continues, subject to a maximum of 1 crore rupees. Moving on, question number 12. Under section 19G of Depositories Act 1996, what penalty can be levied by the board for any contravention where no separate penalty has been provided under this act? So where no separate penalty has been provided for some contravention, in that case, what is going to be the liability? So the answer is D, that is A and B only, at least 1 lakh and maximum of 1 crore. Let's read it. Penalty for contravention where no separate penalty has been provided, section 19G. Whoever fails to comply with any provisions of this act, the rules or the regulations or the bylaws made by or directions issued by the board thereunder, for which no separate penalty has been provided, shall be liable for a penalty which shall not be less than 1 lakh rupees but which may extend to 1 crore rupees. So the minimum is 1 lakh rupees and the maximum is 1 crore rupees. Question number 13. In what fund all sums realized by the way of penalties will be credited? So all the sums that are collected by the way of the penalties, they are credited into what? They are credited into the Consolidated Fund of India. The answer is option number D. It is given under section 19J, crediting sums realizing by the way of penalties to Consolidated Fund of India. All sums realized by way of penalties under this act shall be credited to the Consolidated Fund of India. Question number 14th. Consider the following statements regarding pledge or hypothecation of securities held in depository. A beneficial owner may, with the previous approval of the depository, create a pledge or hypothecation in respect of a security owned by him through a depository. Every depository participant shall give intimation of such pledge or hypothecation to the depository, and such depository shall thereupon make entries in its record accordingly. Any entry in the records of a depository under subsection 2 shall be evidence of the pledge or hypothecation. Choose the correct answer using the code given below. So the answer to this question is E, that is all of these statements, they are correct. So by this we come to know securities, they can be hypothecated and they can be pledged as well. So there is a provision that you can pledge your securities or you can hypothecate your securities that are with the depository, right? Let's read this section. This is section number 12. Subject to such regulations and bylaws, but it is subject to the bylaws and the regulations as may be made in this behalf. A beneficial owner, he has been given this part, he has been given this right, may with the previous approval of the depository, but he has to take the approval of who? The depository first, create a pledge or hypothecation. So a pledge or an hypothecation, it can be created on a security in respect of a security owned by him through a depository. Every beneficial owner shall give intimation of such pledge or hypothecation to the depository, and such depository shall thereupon make entries in its record accordingly. So the beneficial owner, he has to intimate, he has to communicate this to the depository, and the depository is going to record it. It is going to make entries which are necessary, and it is going to record this, that a hypothecation or a pledge, it has been created on such and such security. Any entry in the records of the depository under subsection 2 shall be evidence of a pledge or hypothecation, and any such record, any such entry that a depository has made, it is going to be an evidence that a hypothecation or a pledge, it has been created. Question number 15, the last question. Which of the following statement is true? Any pledge or hypothecation on a security held in electronic format must be done only after informing the depository. A person once opting for the shares in electronic format cannot opt out the shares in physical format again. Depository must compensate the investors for any loss due to negligence of the depository. So the answer is C, that is the first and the third statement, they are actually correct, but the second one, that a person cannot opt out of the electronic form, it is incorrect. He can do so, right? So the second statement is false. So the second statement is false because person can opt out of the electronic format and can hold the shares in a physical format. Now bonus question, question for achievers. What will be the correct chronology if a beneficial owner seeks to opt out of a depository in respect of any security? Every issuer shall, within 30 days of the receipt of the intimation from the depository, issue the certificate of securities to the beneficial owner or the transferee. Beneficial owner shall inform the depository. The depository shall, on receipt of the intimation, make appropriate entries in its record and shall inform the issuer. So you have to comment the right answer below. So that was all for today. I hope it was a helpful session for you. For more such videos, please like, share and subscribe to the channel EduTap. Thank you.